Yes, we were looking at the company's, the bank's account.
For September 1991, and we were at page 771.
Yes.
And so I wanted to take you over to page 818, which is ought to have been an annex to that 30th of September 1991.
So the page again?
818.
818, thank you so much.
And this is now the director's report in relation to that financial statement. And again, you would see at the very first paragraph where it states that the director submit herewith the consolidated profit and loss account of NCB Group Limited and its subsidiaries ended 30th September 1991, together with consolidated balance sheet of the company and its subsidiaries, and the balance sheet for the company to that date, and then it identified the sum, which is shown as a pre-tax profit, which we say that pre-tax.
And where is that? Just show us then where that is in the accounts that we just looked at.
The 23648.
Yes, 232648.
232648. At page 767.
It's the profit. 263, did you say? 348.
232.
232,648. It's profit before taxation.
Correct.
Yes.
It's below that figure that's in brackets 1413.
But you say that's before the deduction of minority interest
Correct.
results.
Yes.
But what can we, and this is all quite substantially later than the date on which I think it's agreed that the term was incorporated into people's contracts. So how do you phrase how you rely on these evidential pointers?
Well, perhaps maybe I should take you to the context within which the PSS came into being. So I could take you to the day before a memorandum which speaks to consolidated profits before tax and actually shows the calculation which speaks to consolidated profits before tax. Our argument is that it is a clear line item because you are dealing with financial people in the financial sector, and so they would have known.
What you're going to show us is a number of accounts more recently than 1980, which we assume are made in accordance with Jamaican GA.
Yes.
And in that, the expression consolidated profits before tax is equated with the figure of profit before taxation. Indeed. As shown in the accounts.
Indeed.
So whatever you call that line, it is consolidated profit before tax.
Indeed, and that's what I was submitting earlier.
Please continue along that line at the moment, and then return to that which Lady Rose wishes you to cover.
Indeed. Okay. And so if we went to 1992, which would be at 771, again, 1992, which would be at 772. 772. Again, we are seeing here that it's a consolidated account. We are seeing that item, profit before taxation, an extraordinary item, just below the share results of the associated companies. If we go again over to the notes in terms of how they explain their significant accounting policies, we'll see that it states that all amounts in these financial statements are stated in Jamaican dollars and that the consolidated...
Could you give us the page, please?
Page 775.
Yes. I think think we've seen this, yes.
At the notes to the financial statement.
Yes, thank you.
Similarly, for 1993, on page 776, there is that line item, profit before taxation and extraordinary items, which is 671096.
But you, reading the notes at 775,
Yes.
you ask us to read this as meaning that even though NCB Insurance Services and Jamaica Orange are shown as only 74 and 65% owned, that there has been no deduction for the missing 26
Indeed.
and 35%.
For the minority, this minority
is from, but there is the deduction for the associated company.
Indeed.
Well, there's deduction for both, but
But it's not for the purposes of calculating the profit share, but on the financial statement, you will see the deduction below the line item consolidated profit before taxation.
yeah. Your key point is that the deduction of minority interests is a stage after
Correct.
the declaration in the line of consolidated profit
Indeed,
before
Madam
taxation.
President.
Yes. And this was standard accounting practice. In fact, I think Mr. Jane's evidence was to that effect.
Indeed.
When he said it was for convenience.
Yes, and in fact, even when the standards changed prior to that 2002 that we're arguing about, the layout was pretty much
The same. Thank you.
So at 776, I was indicating that the 1993 consolidated profit and loss account is also there, the same term, profit before taxation and extraordinary item. And the same notes appear on 780. In terms of the significant accounting policies.
Thank you.
And again, you would see that there is Mutual Security Bank as well as Jamaica Orange Company Limited as minority interest. In 1994, on page 781, there is an item as well, consolidated profit before tax. And the explanation on 784 relating to the significant accounting policies. In this case, there is only one minority interest showing there, one at 785. Same line item, profit before taxation, with the heading consolidated profit and loss account. At 7.
So it's your submission then is broadly that consolidated in the way it's being used in the clause actually just means group.
Group, indeed, milady.
Yeah, because that is what the headline essentially is. It's NCB Group Limited Consolidated Profit and Loss Accounts.
Indeed.
So the revenue is consolidated, the expenses consolidated, the operating profit, including the equity method for associated companies, all that's consolidated. And you say the next line also is?
Is,
Yes.
And in the interest of time, my submission is that if you look through all of these accounts,
Yes.
from 1991 through to 2002.
Yes, if we just run all, I don't wish to take up your time, but if we just run on the pages thereafter, we'll find them all. Is that
Oh, I see. I could do that.
Okay, we can see them ourselves, but
Okay.
you're saying the presentation is the same throughout?
Indeed. And so the pages for, I just did 1993.
You've got to 1995. So
95.
So 96 onwards, is it the same picture?
Yes, my lord.
Yes.
And
And
so-
well, that perhaps isn't surprising if the accounts are prepared in accordance with a
Same standard.
recognised practice in Jamaican GAAP. Yes.
Oh, I see. So for 1996, it would be 790, and the notes would be at 793. Sorry, I forgot that. I'm
So
behind.
just give it, just
789
Just give us the page number, 789 and 792.
and 792.
Yes.
For 1997, 794 and 797. 1998, 798 and 801. 1999, 802 and 805.
Thank you.
Right. In 2001, it would be 806 and 809. And 2002, there's a better copy at 444 at 449.
Did you mention 2000?
2000 would be at 819 and 821.
Thank you very much.
Just looking at page 784, that seems to me at least, which is 30th of September 1994, that seems to be the first time that Edward Gale and Company comes into the list at 50.5%. Right at the bottom there. Oops.
Oh yes, at the last,
Yeah, the
yes,
last one.
indeed. It'll be since 1994,
Yeah.
and which is significant because there's no evidence of the minority interest being deducted in the way that it is being suggested in 2002, which is about 8 years later. What we say in relation to looking at all of these line items and the conclusion of the learned judge when he spoke to the line item being there in the financial statements in different forms, we say that certainly he was entitled to reject the evidence of the appellant on this issue as to whether there was a line item or not, and certainly also in the way that they went about calculating the profit share. And for that, I will take you to the cross-examination first of Alok Jan.
Which paragraph in Mr. Justice Sykes' judgment are you wishing to uphold in this submission?
If we look at pages 58 to 63 of the decision, which would be paragraphs 123 to 139.
Thank you.
Further indulgence. 1, 2, 3. One, two, three, I'm sorry, at page 57.
123 to 139.
Yes, ma'am.
Yes.
And you can see where he starts out. Actually, at 122, where he says, in addition to that, what has just been attributed to Mr. Christie, the court understands him to be saying that there is a line item known as consolidated profits before tax. The concept was not a creation of the new IA standard of 2002, and then he went on to discuss the context, he says, certainly from I think at this point he was looking at how one would interpret the document. So he was there saying that from Mr. Christie and the two accountants, the court understands the very fact that there is an item known as consolidated profits before tax and presented by that name or a similar name in the financial statements by the bank, then that establishes that when the bank used the expression consolidated profits before tax in Circular 33, it knew exactly what it wanted to say because it was known and a common expression at the time.
I mean, yes, 123 and 124 are, from your point of view, critical paragraphs.
Indeed.
Because what he's construing the contract in the context of the time and is saying that consolidated profits before tax was known to be this line item, whether you added the word consolidated or profits before tax.
Indeed, yes, ma'am. And you will see that he had actually gone through the line of cases that spoke about how documents of this nature are to be interpreted.
But I don't think there's been any challenge made to the judges setting out of the approach to interpretation.
Absolutely not.
But there was one paragraph in that guidance which I think made it quite clear that events that occurred after the contract were not of much assistance in interpreting the contract itself.
Indeed, he did say that. In fact,
I think in my judgment in Capita, Wooden Capita, I think I summarised that from earlier judgments. Yeah. Anyway, you say that the judge was entitled, having regard to accounting practice, to say that people in 1980 would know that consolidated profit before tax was a line item.
Was a line item.
Yes.
And that line item. He said from this line item was deducted, and then the minority interest. Tax was deducted, and then the minority interest were taken out. This was well known at the time of the circular. And you will see that the Court of Appeal examined the evidence and found that the judge was not in error, and so the court at paragraph 68 to 69 to 70, and that would be 160 to 161 of the bundle of the Court of Appeal decision. And to underscore the point that we were just discussing, at paragraph 68 of the Court of Appeal decision, you would see where the court took into account the fact that the judge explored in detail the history and matrix of the facts that led the parties to settling the terms of the circular. And I think in this context, the learned judge relied ultimately on the construction or the expert evidence of Orville Christie in his affidavit of March 2016, which is at EB 256, and specifically at pages 289 to 260, paragraphs 11 to 12, and paragraph 18. And I will demonstrate to you.
Bear with me, I'm just struggling to bring up those pages.
I'm so sorry.
Not at all, don't apologise. So, page numbers again, please.
Okay, so Affidavit of Orville Christie 2016, March 2016, EB 256 at 258 to 260. Paragraphs 11 to 12 and paragraph 18.
Thank you.
So moving on with that point, interestingly, you will see that even though the appellant itself relied on the opinion of the auditors in 2002 and identified the line item as consolidated profits before tax for September 30, 2002, and consistently throughout their argument suggest that the calculation was always done by their auditors. Nevertheless, when Alok Jan was asked in cross-examination whether the figure in the 2002, September 30, 2002 accounts, which was 2,209,286, whether that figure represented the consolidated profit before tax, he said he would not interpret it that way. And you will find that cross-examination by Counsel Mr. Miller at page 1208 of the transcript, starting at line 8. And going over to line 1 to 4 on page 1209.
I think we are a page behind you, so I think it starts at page 8 at 1209. Is that good? If you were to look at the same page 230, you would see profit.
Yes, indeed, my lady. And you will see at line 22, the figure I see here is 2,209,286. Right across that you would see 2001 would be the figure, and then the equivalent figure would be 479,608. At 1209 at line 1, isn't that consolidated profit before tax as in the formula for 1980? He says no, that certainly would not be my interpretation. And speaks about the elimination of minority interest being an integral part of what is done in the consolidation process. However...
But all this evidence was in the context of his client claiming that the term consolidated profits before tax was a term of art in the contract rather than anything that was more widely understood. That's what he was talking about. But your position, as I understand it, is quite simply that the profit before taxation in a consolidated account is consolidated profit before taxation.
Correct. And also, my lord, if you look at their letter, if you look at the letter from, or the opinion of PricewaterhouseCoopers that was dated the 23rd of December 2002, where the bank relied on, or the appellant relied on the opinion of the auditors, what they said here demonstrates that it is unsustainable for them to be treating with consolidated profit before tax as a term of art. Because so at
316 at the bottom of the page, they quote the figure from the line profit before taxation. They represent it in this document as consolidated profit before taxation, which is what an accountant would expect.
And also, if you look at the account, the actual accounts at 449,
the figure is the same.
The exact figure is there.
Yes, we saw this when we were discussing the matter.
Yes, I think what Mr. Jane is saying is the opposite way round, that an accountant would think that the word consolidated inherently means that you have to you only consolidate what actually belongs to the group, and therefore you would exclude that. But what he was unable to say was whether actually the term is being used, as my lord says, in a different way, as meaning the line in the accounts before the deduction of minority interests, and you point to that 23rd of December 2002 as actually being contrary to what Mr. Jane is suggesting here.
Yes,
yes, because all consolidated means, as I understand it, is you take the parent company and its subsidiary results together, and you start with the revenue, that's consolidated. You then have the expenditure, that's consolidated. You then have, if it's very straightforward, you go straight to profit before tax, which is consolidated.
And respectfully, that's what they have been doing successively throughout the years, which is the same thing in the 2002 accounts. There's no change.
And there was evidence that the accounts were presented in accordance with the Jamaican GAAP.
Correct. And that is the basis on which and that is the basis on which the learned judge rejected the attempt to suggest that the change in the treatment of minority interest in 2002 was because of a change in the accounting standard. So they were hanging their hats on the fact that there was this change, and that is why they did it in 2002.
Well, before you develop that, I mean, it has been shown to us that there was precious little evidence to support a change in 2002. Do you know, was it the submission of the bank in its concluding submissions that this practice was justified by what happened in 2002?
Yes, my lord, there is the evidence of Mr. Cummings.
It's the closing submissions, I said. I mean,
Oh, the closing submission.
yes, I think we've seen Mr. Cummings' evidence, and to say that that supported the conclusion that something radical had happened in 2002, I wonder if it's sufficient for that. But do you know, was the bank's position at first instance that its justification for what it did in 2002 was a change in accounting practice?
I don't know as a fact because I wasn't there. What I know is what I have seen in the record. So what I've seen in the record is the Newton Cummings affidavit, what he said about the change in the standards at paragraph 32. And then when they got to the Court of Appeal, it seems to me that counsel could only have abandoned a position or a point if it is something that they had argued in the court below. And it is my understanding that reflective in the judgment is their position that they were no longer arguing that there was a change. In fact, I think they said it was an error.
You see, that suggests they argued it before.
It strongly suggests that they would have argued it before.
But do you accept that it's now agreed that this was, as your learned friend put it, a rabbit hole that they went down, that actually, first, there was nothing in the new accounting standard that would have affected how you dealt with this, and second, it only applied to accounts from 2003 onwards?
I wouldn't say that it was I wouldn't say it was a rabbit hole, because at the time when they relied on it, they actually believed it to be true and to justify what they did.
But where did they justify what they did by?
And you say it's Cummings' affidavit,
affidavit is
paragraph
what we are
32.
relying, paragraph 32.
Let's have another look at that, just to see which page number is it.
Affidavit is at 214. And actually started, I feel very, very strong about the point that they relied on it, because in my mind it was put forward as if it were a duty. So if you start at paragraph 7 actually of that affidavit, which is at 215, you will see he says the Banking Act further requires that the bank publishes an audited balance sheet and profit and loss account and an auditor's report, and where the bank has subsidiaries, a consolidated balance sheet and a consolidated profit and loss account. The Act provides that it is the duty of auditors to advise the chief executive officer and directors of any change in accounting policy or any presentation of or of any failure to present facts or figures which in the opinion of the auditors has the effect of misrepresenting the financial position of the bank. Thus, the bank is required to implement, maintain, and adhere to sound accounting practices at all times. Then at paragraph 31, that paragraphs 15 to 18 of the Ducasse affidavit are true. For the year ended 2002, there was no distribution made under the profit sharing scheme, as the bank's auditors advised that in accordance with International Accounting Standard 27, consolidated financial accounts, statements and accounting for investment subsidiaries, which binds all auditors in Jamaica, the profit attributable to minority equity holdings in the bank's subsidiaries should not be included in the financial statements dated 20th September 2002. The bank was further advised that the same should not be included in the consolidated profits before tax for the purposes of determining whether the disbursement is due under the profit sharing scheme. And if we went down to paragraph 36, you will see, he says, even with this proposed amendment, as the clause is dependent on the agreement of the auditors, the staff will not be able to include the minority interest profits, as this remains a breach of IAS 27. So it is in those
It's
circumstances.
IAS 27.
That's the new
one.
Yes. So that's why I was saying, my lady, that I would not quite treat it as a rabbit hole. It was a substantial part of their defense.
Yes, but it doesn't stand up in the light of the expert accounting evidence. That's why I was wondering whether it was advanced as a substantive defence at the end of the trial. And I think the answer is you can't say except you infer from the Court of Appeal's concession that it must have been.
I crave indulgence. Mrs. Roberts-Brown was there. May I take a moment to confer with her, please?
Please do.
I was trying to find the concession in the Court of Appeal.
Yes, ma'am.
It is there quite early on, I think.
Concession. I crave indulgence, ma'am.
This is paragraph 88 on page 168. In the course of its submissions before us, the appellant no longer claimed that it was a change in accounting standards which mandated that minority interests be deducted from the figure identified as consolidated profits before tax. Counsel for the appellant has acknowledged that the reason which the appellant advanced for the deduction was wrong, as it was not true that the deduction was required due to a change in accounting standards. So it does seem that it was argued below.
Yes, and at 109, which is at page 50, they deal with it as well.
Page 109?
Paragraph 109, page 50, sorry. This is in the Court of Appeal. Oh, that's sorry. It's the Sykes judgment.
Yes.
I beg your pardon. So he certainly seemed to think, based on Mr. Cummings's evidence, that the bank was putting forward a change in accounting practices. But then he cites Mr. Jane's evidence as refuting that, which may well be why it was dropped.
Bear in mind, lady, that Mr. Jane came privileged. Jan was also appointed as an expert, so he would have come after the defense is in. So we are looking at the affidavit of Cummings as the essence and substance of their defense.
Yes.
And you would also see that, I think, paragraph 71 of the Court of Appeal judgment as well, page 162. We say it was a substantive argument.
Well, he certainly got hold of that idea, but you say it was based on Mr. Cummings's evidence.
In fact, in his analysis, he mentioned it specifically as the basis on which the bank was putting forward their defense. I think he described it graphically as the evidence of Cummings being suspect of the shifting sand and of the Damascus Road revelation being, so it was. Right, at 150, the learned judge said, Mr. Cummings' evidence reveals another reason why the bank's Damascus Road revelation must be rejected. It is too plain that Mr. Cummings is using the change in accounting standard in 2002 to say what a document meant when it was created in 1980. That alone proves a point. If the logic of Mr. Cummings, Mr. Jean, and Mr. Sadler is correct, then as the standards change, so too with the meaning of clause 2.
At the end of the day, this may be, as Lady Rose says, a rabbit hole, because when the judge summarised at first instance the principles of contractual interpretation, at paragraph 140, subparagraph 15, page 67, the judge says it's important that post-contract experience is irrelevant to the interpretation of the contract.
Indeed.
So whether or not the bank operated the scheme as they say or as you say may not be of much relevance to the interpretation of the contract. What I think is relevant to the interpretation of contract is an understanding of what Jamaican accounting practice was, and the accounts that you show us from 1991 onwards seem to be accepted by everyone as being a representation of that practice.
Indeed, my Lord. I would only make equivalence. I would only make one further point, though, my Lord, if I'm permitted, in relation to the Houghton Cummings' evidence. It is this, because it does suggest, even at least inferentially, that if they are relying on a 2002 standard for now deducting minority interest, it could be readily inferred that they had never done it before, because they are saying this is the basis on which I have done it. It would be open to the courts below to infer that they had never done it before.
But this is an interesting skirmish, but does it have any effect on the critical question, which is, what does the contract mean?
Well, which I do believe then, my Lord, that the learned judge admirably discharged his function as the judge in terms of and faithfully followed the law in terms of the interpretation.
Well, no challenge has been made to his summary in paragraph 140 of those 15 points.
No, my Lord, no challenge. And in fact, I had made a note of that no challenge was made to the learned judge's summary, and overview of the contract interpretation.
Well, I think there is a nuance here, which is that accounting standards change and are tweaked, and further advice of the regulatory body is given that may result in small changes to how accounts are drawn up. And it may be that when a contractual clause refers to an item which is included in accounts, that has to some extent, move with the times so that one wouldn't regard that as frozen in time, so that you would then have to recalculate that line as it appeared in 1993, in 1994, in 1997, in 2000. Those lines may take into account minor changes in the guidance that the accounting regulator gives. I don't think that would be affected by the kind of major change we're talking about now. But I think it may well be inherent in your answer, in your case, that this is looking at this line in the accounts, but insofar as that line in the accounts is calculated in a slightly different way in later years as a result of changes that are made in accounting standards, you would have to still look at that line as it appears pursuant to those accounting standards, and not say, oh, well, we have to look at all the background information and work out if you'd applied the accounting standards in 1980 to the figures in 1997, what would you have got? I mean, that would be an impossible process.
And I think maybe that's why His Lordship focused on, let us look at the contract itself. What does that mean?
Yes. So it may mean consolidated profits before tax silently as calculated from time to time in accordance with the then current standards as at 1990 or 1998, rather than always as at 1980.
Yes, right.
I think that must be right.
Yes, I wouldn't demur to that at all, but I think the point I was making, that the actings of the parties in implementing the contract and their understanding of what it meant is not particularly relevant to interpreting a contract from many years before. We
don't have to answer the question whether, if an accounting standard suddenly changed so that line that we've been looking at, or they suddenly decided, actually, you need to deduct minority interests further up the stack before tax is deducted. They need to, for example, if there was an accounting change that said, actually, you need to treat subsidiaries in the same way that you treat associated companies, for example, then there might be a difficult question as to how then you interpreted the clause, but that's not a question that we have to grapple with.
Fortunately, for us. For us.
Yes.
Thank you.
And so now we'll move to demonstrate as well that based on the circular, that all the parties knew in any event how it was calculated since 1980. And we'll be doing that by looking at communication between the parties, the circular, as well as and other memoranda. So if we start with the hearing indulgence.
What was the date of the 1980 circular?
Circular 33.
16th of December, 1980. and it is at page 333.
Well, that's a memorandum to the Board of Directors.
No, the circular is at
That's
2.
at 334, I think.
Is it 216? 286? What's that? My handwriting.
Staff circular
286. I think it's 286. My handwriting is getting the better of me.
286.
Let's see. Right, so it would be 286.
So it's the 17th of December.
17th of December. And what we will see is that when the circular was being put forward to the board for approval on the 16th December 1980, there was a calculation that was done by the bank, and that is found at page 332, 16th of December 1980.
332.
332.
Okay.
As a memorandum to the Board of Directors, profit sharing.
And this predated the circular.
It says it's an amendment. It says, in the circumstances, we seek the board's approval to amend the rules of the profit sharing scheme so that the amount shall be 6% of the group consolidated profit before tax and all other items. So this is the document that was submitted for the approval of the circular. Yeah, at 6%. At 6%.
It seems to me to follow the same sequence. What you do is you consolidate
Profits.
expenses, you consolidate the profits, you then take off tax, and then you distribute the
Correct.
share, and that reduces your profits. So,
And there's no deduction here of minority interest.
and there's no deduction of minority.
Interest.
Do we know if there were there were subsidiaries with minority shareholders back in 1980? I'm not sure.
I
think
I know they had subsidiaries, but it would be going too far to say that I know that they had subsidiaries with minority interest in 1980.
Well, I think we've got a list of the subsidiaries at page 511 in 1980, and none of them are minorities. I think
Which page is this?
511. Recollection.
Well, we don't know.
Do we know what the shareholding was?
Sorry, let's see. I've got the wrong page number, sorry. This is 180.
1980.
It's 511 is a letter of 2000.
Yeah.
Well, it says at 511, at that time, the group was comprised of the following companies, and those four, Carp and Noxid.
Yeah.
4 subsidiaries, yes.
Yes, 4 subsidiaries.
Well, Carp and Noxid certainly seem to be 100% as at 2000, but we don't know, I suppose, whether they were in 1980 as well. Anyway.
Yes. Well, we simply don't know whether or not the existence of minority shareholdings was an issue at 2000. In the evidence before the judge, that wasn't made clear, I take it.
I think what is also helpful on that point of how it is calculated, or the profit share is calculated, we could look at page 3 or 3, which is a memorandum to the Board of Directors from then General Manager of Staff, McFarlane and Banks. And again, in that second major paragraph, it speaks to, based on the 1988 results, it explained it, how they arrived, and they used the same formula groups, consolidated pre-tax profit, and in that workout, there's no deduction of minority interest either. There is a nuance in terms of them giving them an additional 2%, perhaps because they did very well, but the point is that this is a calculation that was done by the bank.
But it's a calculation done years after the agreement was made.
But we say honoring the content, intent, and spirit of the agreement.
Right, and you say that if we were to look at the 1988 results, that 5026447 figure would be 6% of that line that we've been looking
at. Indeed.
Do we have the 1988 results? I don't.
No, my lord.
We don't.
We don't, my lord.
But again, this all falls within the category of the party's implementation of the contract.
Indeed. And there is also paragraph 20 of the Ducasse affidavit, which was accepted by which one was accepted by?
This was accepted by Mr. Cummings, was it?
It's accepted by Mr. Cummings.
And paragraph 20 is that page?
I crave indulgence, my lord, in the interest of accuracy. I just wanted to check something.
Page 212. So I don't think paragraph 20 is in dispute. I mean,
that's, yeah, just depends what you mean by consolidated profits before tax.
Yeah.
Right, so what is here at 715, at paragraph 20, is the 2000 calculations, and at the very last line on page 715, we see the group profits before taxation. And if we look at the evidence or the cross-examination in the transcripts of Malcolm Sadler, we'll see that he says in a broad sense, he accepts this calculation as being...
So which calculation are we talking about?
The calculation in paragraph 20 of the Ducasse affidavit.
And that's a page, sorry, this is a page 716?
716, yes. So it starts at 712, page 16.
Misunderstood. I thought you were referring to the earlier affidavit.
No,
but
I'm
wait,
sorry.
this one.
716.
So it was accepted by Mr. Sadler.
his words were in broad terms. He accepted that this was the calculation of the formula, an accurate calculation. Can you find it for me, please?
Where do we see that?
I'm taking you to that. Very indulgent.
Do we have the 1999 accounts?
1999?
Yes, this is the NCB Group Limited in 1999.
Yes.
805.
805.
The 99 accounts. The 1999 accounts is at page 820.
802 and 828. Page 820.
820. Is it 821? On 819.
No. That's the 2020 accounts. I think we should try 802.
It's the 1999 is. So the shareholders' funds from 1999 and the consolidated profits figure is the same.
And you're taking us to Mr. Sadler, I think.
Yes, my lord. It's kind of voluminous, so I'm just trying to get to that area in the transcript. I found it. I'm grateful for the indulgence. In the transcript, at 1725, perhaps you could start at 1724 of the transcript. At line 15, says, yes, that's what he's saying here.
Sorry. It's talking about Mr. Stewart, is it, to page 1724?
Yes, my lord. Mrs. Brown, Mr. Stewart, based on what Mr. Stewart has here, do you agree that we would calculate the profit share?
So this is Mr. Sadler.
Mr. Sadler, yes.
Is being cross-examined.
Yes, my lady. And starting
about
at
what Mr. Stewart said.
On what, Ms. Ducasse? The calculation.
He goes on at line 16. We get a reference to
Ducasse, yes.
Ducasse.
And the year 1999, 2000, yes. Was the profit share triggered in 2000, yes. If I should do the calculation, it possibly would be, I can't go line by line, but the formula is correct. That the basis is, it has errors throughout the document, so I couldn't, the formula is set out there. Is that correct? Answer at line 13 in a broad sense, yes. I think in a broad sense, yes, has to be construed in the context in which there was some transposition of the numbers, so that's why he was saying that there are some errors in it.
But Mr. Sadler's position was quite clear in his affidavit, was it not, that you had to take out the minority interest. So how can we take this general statement that the formula was correct in a broad sense as contradicting what he said in his affidavit? His evidence was that certainly in 2002, the thing wasn't triggered, the formula wasn't triggered.
Because her deductions didn't take out minority interest, my Lord President, and also...
Yeah, but you can't really rely on that to admit her evidence. Her evidence was only to be admitted if it was accepted by one of the...
It was a different affidavit, my lady. It was that first affidavit of... This affidavit, it was admitted under PS2. This particular affidavit was admitted as PS2.
Sorry? Which particular affidavit?
The Ducasse affidavit that we had earlier looked at on page 210.
Yes.
Is part of the exhibit PS2.
And PS2 is whose exhibit?
A clever indulgence, my lord.
Pardon?
The whole of this is PS2.
Well, it's down in the list of exhibits as GS4.
Yeah.
GS4. GS. GS. GS, I see.
That's probably Mr. Sadler.
Yeah.
This is
See what this is taking? Yes, Mr. Sadler produced Jean Ducasse's affidavit and then commented on it in his affidavit. And there's nothing in his affidavit which accepts that Ms. Ducasse was right in her calculation.
My lord, it's a different affidavit. This affidavit is part of...
But what of Ms. Was any of Ms. Ducasse's evidence accepted by the court? She wasn't called for cross-examination, was she?
No, my lord.
No. And so unless her evidence was accepted by a defendant's, by a bank witness, does it have any standing at all?
So there were two separate affidavits, my lord. There was that one which was not admitted into evidence.
Yes.
The one to which Mr. Houghton Cummings commented on, and the learned judge had indicated that he will only rely on such portions as have been admitted to be true by the appellant.
Yes. And
Then, my lord, there's a separate document which is attached to the affidavit of Paul Stewart, being PS2, which starts at page 601 of the bundles and goes over to
Mr. Sadler's. There was a separate affidavit from Miss Ducasse, which was attached to a witness statement of who?
Paul Stewart.
Well, how can that make it evidence?
It was an exhibit, but bear in mind, my lady, that the matter commenced as on a fixed date claim form. There was no objection to the evidence. It was relied on throughout the proceedings.
Did the trial judge in any part of his judgment place any weight or even refer to Mr. Ducasse's second affidavit, which was part of Paul Stewart's exhibit?
No, my lord. No, my lord.
Well, what use is it to us now? Well, perhaps we better move on, because we do want to hear you on the question of interest. Allow yourself adequate time to address us on that, please.
So the short point we make is that the learned trial judge was correct in his construction of the document, the circular. And in terms of the principles that he relied on in the seminal cases, including Arnold versus Britain, Wood versus Capital Insurance, and the celebrated case, of course, of investor compensation. His application of those principles have not been challenged. In terms of his application, we see where he relied on the historical context of the matter. He looked at several documents, and which were the same documents that were also relied on in the Court of Appeal when they were looking at the historical context and the discussion between the parties. We say as well that when you look at the financial statements and the relationship between the parties over the years, and particularly having regard to the reason that was given by the bank for the triggering of the non-triggering of the profit share in 2002, the court was correct when it found that the line item consolidated profits before tax. Well, when he found that the documents, the financial statements before him, that there was always in the understanding of the parties a line item known as consolidated profits before tax, and that is the line item that is to be used to calculate the profit share, and that is a different principle from looking at the financial statements and dealing with the accounting concept of allocating profit as between subsidiaries and parent company. In fact, on the final point, in terms of the role of the auditors, we say that even when you look at the evidence, you will see that whether it is the profit share or the consolidated profit before account sum, that is ordinarily prepared by the appellant, and the auditors perform their usual mathematical or arithmetic check as found by the judge, and that there was no veto power in the accountants. As Christie said in his evidence, what they, as agreed by the auditors, operated on was the term consolidated profits before tax, and in determining that sum, the accuracy of that particular sum. And in fact, in the evidence of Malcolm Sadler, you will see that, which I think was also accepted by the judge, that it is the accountants who work out the figures, and the auditors do the confirmation. And that is found at 1594 of the transcript, lines 20 to 25, and on going over at 1595 at line 1.
Now, whose evidence
Line 1
is
to
this?
4, Mr. Malcolm Sadler.
When he says the accountants,
Correct.
is that also PwC, or is that
No,
the
internally.
internal accountants?
He was clear that it was internally. If you look, milady, where it says at 20, he says when you say it has to be worked first, is that you do it internally, you work out the profit share calculation internally. Answer yes. So it's the accountants internally.
Yeah.
And also that is that principle or approach to dealing with the calculation of the.
So they were just checking the arithmetic.
Correct. Correct. And that the evidence of Alok Jan is in alignment with that statement as well. So that would be at 1548 at line 21. We're starting, yes, line 21. And he says, in answer to, I think it was Ms. Brown, yes, I remember the audit. This is, in my view, not quite an accurate description, because we as auditors do not actually perform the consolidation. It is the bank and their accounting staff that perform the consolidation. We audit the consolidation and issue our opinion. And that, in my mind, is also consistent with how the standards operate. So at the end of the day, the audited statements is although based on the opinion of the auditors, is owned, as it were, by the bank. And so that is also why we say that the auditors have no role.
Just pause for a minute. Was that line of question addressed to the preparation of consolidated accounts, or was it addressed to the calculation of the entitlement of the staff?
It was addressed and directed at the preparation of the consolidated accounts in relation to Mr. Jan.
The consolidated accounts, generally?
Yes.
So Mr. Jane's evidence there has no bearing on who does the calculation of the
profit share.
Of the profit share. If it's talking about the consolidated accounts, that's just the public document.
Which has already been audited, presumably.
Hmm?
I'm just wondering in the context. I mean, you're picking out phrases from an extensive cross-examination. I just want to know what was the task that was being performed by the company? What was the task being performed by the auditor? Was it the preparation of the first draft of the accounts, or was it the first draft of the staff's entitlement?
If I may take you, my lord, to my friend's submissions or written arguments.
No. Let's stick to the transcript.
Yes.
And see what it says, please.
Okay.
What was the line of cross-examination that was going on here? In 1546, there's certainly there a discussion of whether a profit share is payable.
At line 16.
At 16 to 21, but what is it that he's responding to when he says who does what? What's the last part? Soon after the consolidate.
I suppose if you go back to the staff circular, then the consolidated profits before tax have to be agreed by the auditors.
Yes.
And so the role of the auditors is defined in the circular.
Indeed.
And so the witnesses are giving evidence as what they perceive their role to be, and, rather than what the contractual term is.
So they have a double role. They have a role as the auditors of the accounts, which are prepared by the internal accountants and then audited, and those are then the published figures for all purposes. One of those purposes then being look at the relevant line and work out what 25% of that is, and then and that then also is separately checked by the auditors to make sure they've picked out the right figures from the audited accounts. That's how I rather think that it worked.
Yes, my lady Rose.
And if you're thinking of the task of the auditors, the actual staff circular doesn't really involve them in the next bit, which is the profits is in excess of 25% of the shareholders' funds. But obviously they've taken on that task.
Anyway, we better let you make progress.
So I was basically wrapping up on this point, it being in terms of the role of the auditors. We say that based on the unambiguous terms of the circular, their role was simply to confirm what the consolidated profits before tax is. We also say that in relation to my friend's submission, I don't know if it takes the appeal anywhere, regarding whether there was an inconsistency in terms of the orders that the judge made, because the court made an order that I
don't think you need to address us on the inconsistency of the orders.
Indeed.
Maybe we don't, yes. Because the judge gave an explanation for that, and while he may have slipped in one declaration which might have come within his self-denying ordinance, that's neither here nor there. Thank you. Can we hear you on interest, please?
Yes, ma'am. I will now yield to my learned.
Yes, of course. Mr. Brown. Yes, stand in front of the microphones. Because of the appellant going on longer than allocated, you have over 10 minutes to address us on interest.
On the matter of interest, the appellant has stated that interest, as she has submitted to King's Counsel, is to be as pleaded in the amended fixed date claim form, which is at the commercial rate at the date of judgment. Our submissions are that implicit in the term at the date of judgment, it would mean that it would be from the breach date to the date of judgment.
Well, that's the opposite of what
That's
it
our
says.
submission.
That's the opposite of what it says.
Yes.
Yes, implicit in what we're saying in terms of...
Well, how can something that is the opposite of what's said be implicit in what is said?
Based on the facts, let me explain. Based on the fact that where the claim states that interest on the judgment sum at the commercial rate at the date of judgment was in the amended fixed date claim form. Due to the fact that the commercial rate that would be applicable would be what would be determined at the date of judgment. It is always...
Why, say for instance, the commercial rate at the date of judgment was, say, 50%, and the commercial rate in 2003 was 10%. Well, why does one assume that you should get more than 10% at the earlier stages?
Well, we would not...
And sorry for the follow-up
Based on the evidence...
why not comply with the rules which requires the date over which you have to claim interest to be set out?
Well, with respect to the rules, my lord, the claim form actually states...
Where is the claim form?
Page 14 is the relevant
14.
paragraph.
That would be interest on the judgment sum, that's paragraph 10, at the commercial rate at the date of judgment.
Now, normally in awarding interest at the commercial rate, particularly in a trial occurring sometime after the events in question, if you are basing your claim on the wrongful withholding of funds, then the commercial rate would fluctuate depending on the bank rate over time, wouldn't it?
It would.
So are you saying this means the commercial rate or rates as ascertained at the date of judgment? Is that what you're saying it means?
No, well, without more, it would obviously be absurd to come to that conclusion,
Yes.
that it would be at the date, that you just use one fixed rate.
I mean, you, I think,
However,
were instructed at first instance, and did you attend the hearing on interest?
yes, I was there.
And what was the claimant's position before the judge at the hearing on interest?
Well, the judge actually sent us to, as both parties, to go and work out what rates we'd be using and to come back by way of a consent order, and we both came back with dates setting out the commercial rate that was to be used and from what period of time. So we actually
For
looked
what
into the bank
period of time?
where we started from my recollection, we started from the date of the breach. And we looked at the average Bank of Jamaica rates from that period of time.
That's what the judge asked you to do.
Yes.
That's at page 99, paragraph 27, subparagraph 2. But what I'm interested in is at the earlier stage, at page 93, paragraph 2, there were written submissions made to the court.
Yes.
In those written submissions, were you claiming different rates for different years from 2001 to 2017? Or in those submissions, did you make it clear that you were claiming interest throughout the whole of the period from 1st of October 2002?
Well, I do believe, I don't have those documents with us.
Yeah.
We did not put them in the bundles, but based on what I remember, and unfortunately, we don't have those written submissions, but I do believe that we were claiming from the date of breach in those submissions. We don't have those submissions in the bundles. And based on those submissions that were made, because the other side, as I said, we were all sent to make written submissions. We were also asked to return to the court with the various rates that should be used in terms of the average rate for over each year,
Right,
which we looked at.
Yes, well, it's one
feedback.
thing to say to the parties, please go away and agree the rates that would be used if you were to get an award of interest over that time. Parties are often able to agree those because they are objectively ascertainable facts. But I think what we're interested in was what were the opposing positions being put to the judge on the period for which interest should be awarded.
I cannot recall there being any opposition with regards to the period.
Will the written submissions before the judge still exist in the files of those instructing you? Do you know? Or will the record be in the court?
The written submissions, we would have filed it in the court.
Yes.
Court
And
register.
would the court still retain such documents as a matter of
I would
course?
believe so, my lord.
So if we were to ask you to obtain for the board the written submissions both of your side and the bank, I think that
should
would
be
be
able to
something
get
that we'd welcome to have
should be
sight
able
of, because that is part of the record of proceedings, which may be relevant to our determination.
Yes.
So could you arrange to have that produced within 7 days, or is that too tight?
Beginning to feel a lot like Christmas.
14 days of it.
That's only the 19th. Okay. So it'll be long till the new year. It interferes with the preparation for the
All right, okay, up to you.
Well, lord, based on the time that we're into, when we go back, it's basically 1 week before court will be closing. So would January be
So you'd wish it to be early in January then?
January?
Yes. So if we were to say, let's see, it's now the 12th. If we were to say, I haven't got my diary on me. What is the end of the second week in January? Whatever date that is.
We start on the 11th as the beginning of term, isn't it?
So Friday is the 12th. There's Friday the 12th of January or Friday the 19th of January.
Yes. Could you do it by the 12th?
The 19th of
The
January.
19th.
Yes.
Yes. Okay. Well, I mean, either side, if they can access those documents, I'd be very grateful. Because if you can't remember, there's no point pressing you on that matter. Please continue.
Yes, my lord. Based on the, okay, so in terms of the submissions, we will produce those as requested. Based on the seminal principle that interest in contract cases would commence from
I think from my
date of
perspective, there's absolutely no trouble. If you claimed it, the ordinary rule is it goes back to the date upon which the loss was sustained. But the issue here is you didn't claim it for going back. And the reason I'm interested in what the submissions was this an issue before the judge? Did the present appellants object to the claim for interest going back to 2002?
So, as I say, my lord,
Yeah.
at this stage, we're unable to
I appreciate it.
present that. So is it that you would prefer us to make written submissions with respect to that based on
What is the basis on which you say,
Okay.
given paragraph 10 of your pleading, why do you say you are entitled to interest going back earlier than the date of the judgment?
Well, my lady, this is first and foremost a fixed date claim form that we have used. A
Yes.
fixed date claim form has been used here. And with regards to the rule, we have set out that we are claiming interest to start with. It is not that it has
So
not been
where is
stated.
what are the special rules that relate to fixed date claim forms that you're relying
This is
on?
Rule 8.7 and Rule 8.8. Look at those.
Sorry, Rule 8.8?
Rule 8.8 of the Civil Procedure Rules.
Yes. I mean, 8.7 is very simple. It's the date from which it's claimed.
Rule 8.7 speaks to the claim form. Rule 8.8 speaks to the fixed date claim form.
But where does 8.8 deal with interest?
It's 1909. It's the civil, looking for Rule 8. It's page 1909.
1909.
You see, if you look at 8.71 on 1909, it says the claimant must in the claim form other than a fixed date claim form set out A, B, C, D. But then it says in 3, which is not so limited, a claimant who is seeking interest must say so in the claim form and include all those particulars. Now, it would seem to me that a fixed date claim form is a kind of claim form, and there's nothing that disapplies what's in 8.73 from a fixed date claim form. But you may be able to point me to something that shows that that's wrong. Or not.
Well, lady, I'm looking at 8.4. Let me just first and foremost deal with, we seem to be having some difficulties with regards to bringing up the claim form, the rules at this point in time. However,
It's 1909 is the page we have for the rules.
Rule is repeated at page 186.
Sorry?
Sorry, just to be helpful, the rule is repeated at page 186 in the Court of Appeal judgment.
okay.
Thank you very
Thank
much.
you.
Yes, so this is a rule with regards to 8.7, and when we look at Rule 8.8, which speaks to the fixed date claim form, it says the claim form must state the question which the claimant wants the court to decide, the remedy which the claimant is seeking, and the legal basis for the claim to that remedy. And it goes on to where the claimant is claiming in a representative capacity, things of that nature. However, it does not speak to the fact of interest in that rule.
Maybe that's because it's covered by 8.7.
Right, so in terms of Rule 8.7, we're saying, my lady, that this rule, due to the fact that the in the fixed date, the amended fixed date claim form, the claimant or respondent, no, also had in there such further and other reliefs as this honorable court deems fit.
And where's the authority for saying that that can include anything you like?
Under Rule 8.7, 1B, it states clearly there that the claimant must specify any remedy that the claimant seeks, though this does not limit the power of the court to grant any other remedy to which the claimant may be entitled. And it is also on that basis that the Court of Appeal.
But that specifically doesn't apply to a fixed date claim form.
But a fixed date claim form is designed to be simpler, am I not right?
Yes, yes.
Yes, so it'd be odd. It would be an odd interpretation, it strikes me too.
But to deprive the claimant of interest, and I do believe that if equity is to be done and fairness to be done to the claimant, based on the fact that this is a typical breach of contract claim that is being made here.
But why didn't you claim interest going back to the breach then?
It's not that, well, the document states that it's interest at the commercial rate. However, throughout our presentation before the trial judge, it was clear that we were speaking of a breach of a contract, and implicit in that breach of the contract, it would mean that compensation would have to be sought on behalf of the claimant, and in that case, it would have to go back to the date of the breach. And my lady, if I could take you to...
You've only got a minute, and then I must hear from the appellant.
If I can take you to Ryan Hunter, which is found in our page 1889 of the bundle, paragraph 79. Justice of Appeal MacDonald Bishop, in that case, made it clear that the Judicature Supreme Court Act supersedes the rules of the court.
This is page?
Page 1889, my lord.
And you're quoting from?
Ryan Hunter and Chantal Richards and Stephanie Richards. The Court of Appeal judgment.
Yes, we have this in your case.
Well, that's a date making the declaration.
It might have been very simple to apply for an amendment to the claim form at the time, because there's absolutely no prejudice that I can see, and the parties would have been able to address the appropriate rate of interest. And that's why I was interested in whether, in effect, people were proceeding on the basis of some amendment, or they understood between them that interest was being claimed right from the beginning.
No, we can also take you to Rule 26.9 of the Civil Procedure Rule.
Well, if your other points are in your written case, then I think I must stop you at this point, because your party has had its allocated time. Is this point in your written case?
With regards to 26.9, no, that is not in the written case. But just 1 second.
Well, where is that in the bundle?
May I have just 1 second, my lady, to just...
Well, if you give us the reference in the bundle and then sit down, please, because your time is up.
Rule 26.9, Millard.
Or perhaps you just send it to us if you could.
We will.
Yeah.
Yes.
Thank you very much.
I'm obliged.
Yes, that's very helpful. Thank you. Yes.
Please, Millets. Just in relation very quickly to my friend's points and interest, I showed you where the Court of Appeal set out the relevant rules at pages 186 to 187. I just wanted to draw to your attention that on page 129, it was clear that at paragraph 14 on 128, the judge says, the Court of Appeal says, in this appeal, we have to consider as the grounds below will show, broadly speaking.
So which paragraph are you reading from?
Numerical number 14 on page 128 at the very bottom.
128.
It's a judgment of the Court of Appeal, numerical
Yes.
paragraph 14. I don't know if it's
Yes,
128 for you.
speaking, whether, yes, whether.
You have to, and I take it to the C. C on the next page. C in letters.
Yes.
Whether the judge was correct in awarding interest with effect from 2002, although in the amended fixed date claim form, the respondent had sought interest from the date of judgment. So it was clearly a point raised squarely on the appeal by the bank. And on page 187, you see that the Court of Appeal made a specific finding or statement, wouldn't be a finding, a statement in relation to the law, numbered paragraph 139. Rule 8.8 of the CPR does not speak to what must be included in a fixed date claim form where the claimant seeks an award of interest. Upon a review of rules 8.7 and 8.8, in my view, the provisions of 8.73 would apply to a claimant who files a fixed date claim form and seeks interest. And of course, 8.73 is the one that says you need to specify the date from which interest is. And that was the Court of Appeal's statement on the matter. I won't want to waste any more time on that. Because
what do you say about this point as to whether those words in brackets in 8.71 would apply also to a fixed date claim form?
8.71?
No, if you go to page 1909, which we were looking at before, right, 8.71. 1909. We were looking at it a moment ago, the rules.
Oh, the rules. I don't have it in front of me, my lady, but 8.71, the word in square brackets.
So that 8.71, it says in the top, other claimant must in the claim form other than a fixed date claim form. Okay, so that bit doesn't apply to a fixed date claim form, but the Court of Appeal, you say rightly, said that 18.73 does apply to a fixed date claim form.
Yes.
But the oddity, as my lord pointed out, is that in 8.71b, although it says that the claim form must specify any remedy that the claimant seeks, it says this does not limit the power of the court to grant any other remedy to which the claimant may be entitled. Now, slightly oddly, one might have thought, when you look at 8.81, where it says at 8.81b that the fixed date claim form has also to state the remedy which the claimant is seeking and the legal basis for the claim to that remedy, it doesn't contain those words, though this does not limit the power of the court to grant any other remedy to which the claimant may be entitled. Now, as my lord pointed out, it would be rather odd, given that a fixed date claim form is a subset of a claim form, for that protection for a party not also to apply. So do you accept or do you not accept that one should really read those words in brackets in 8.71b into 8.81b as well?
we're asking if those words in brackets, other than a fixed date claim form,
No.
should be read into 8.8.
No. I'm asking whether the words, though this does not limit the power of the court to grant any other remedy to which the claimant may be entitled, whether those words, as they appear in 8.71b, which does not apply to a fixed date claim form, should be read into 8.81b, which does apply to a fixed date claim form.
I don't see any reason, I don't see any basis for doing so, my lady, because they are not there.
Right.
And there must be a reason why they are not there. And the Court of Appeal has said that 8.73 subsection Roman 3 applies to fixed date claims form.
They do, but they then go on to say that statutory provisions have empowered the court to
Yes, but I'm not challenging the court's power to give interest. That's not being challenged. That power, and all I'm saying is that that power has to be exercised within the pleaded claim, and you didn't plead it. I'm not going any further than that.
As I understand the dispute in relation to interest, you're not suggesting for a moment that the appellant was prejudiced. It had an opportunity to make this point in front of the judge and could put forward any arguments. What prejudice is there to the appellant?
Well, I don't know what the discussions between both sides were. The trial judge told them to go away and speak. I mean, I don't know what was in the mind of the claimant when they filed their fixed date claim form and saw judgment from the interest from the date of judgment. I would be speculating. But it would have been very easy for them to claim it from the date of the breach if that was what their intention was, and they did not do so. And the rules require them to do so, and they did not comply with the rules.
Yes.
But I don't want to waste my reply time on that, my lads, because there is a point that I wish my friend, Mrs. Gibson Henley and Casey, took you to the affidavit of Orville Christie, and I wished to. She took me some paragraphs in that affidavit, and I think for completeness, if you could look at page 262.
Page?
262.
262, thank you.
Christie's affidavit. Paragraph, the one above 19 at the top of the page. 4 lines down from the top. Both accounting standards treat minority interest in the same way, that is, exclude the total profits before tax to arrive at the profit attributable to the majority shareholders. And this affidavit refers on page 265 to an exhibit of Mr. Christie's called OC1. And that shows how the calculation he did. And that was at page 440.
Which paragraph in Mr. Christie refers to?
OC1, that's 29 on page 265. You saw the reference there, my lad. And OC1 is actually on 440. You actually see OC1 at the top of 440. And this, are you with me on 440, my lads? And this at OC1 at 440 is what Mr. Christie used to calculate to get over the 25% threshold. Do you see that?
Yes.
And on the right-hand side of the page, he contrasts it with the Pricewaterhouse calculation. And you see the 24.4% is the result of the Pricewaterhouse calculation. You see that, Mullins?
No,
Oh,
not on this page.
sorry. OC1 has two schedules, Schedule 1 and Schedule 2. So you flip to the next page, Mullins.
Yes,
You see Schedule 2 on the next page, Mullins?
yes.
And if you go to the bottom, you see 24.4%.
So the only difference is taking out the 63,121.
Yes.
That's the only.
Yes, but the crucial difference is that is less than 25%.
Yes.
But we know that.
Yes, I know that, Mullins, but I just wanted to say that the bank responded to that, to say why it was that that approach was not tenable. And that, if I could just take it, show you, give you the page numbers, the bank's response, the tables prepared by the bank are at 422 to 423, and Mr. Sadler, I wanted to say, give the main evidence on behalf of the bank, not Mr. Cummings. I wanted to correct that. And it's Mr. Sadler who at 422 to 423
422 to 423 are the tables you referred to.
Yes, it's commenting on Orville Christie's tables. So if you look at 422, you see Mr. Sadler has three scenarios: scenario 1, scenario 2, and scenario 3, using JGAAP accounting standards. Am I going too fast, Mullins?
Yes.
Sorry.
No, I see what you're doing, but where's this point taking us?
This point is taking us to the fact that whether under your lordships had asked earlier about different standards and what would be the effect of different standards. Mr. Sadler has done these calculations. Mr. Christie's one in scenario 1, Pricewaterhouse's own in scenario 2, and then there's an alternative one in scenario 3. And on this page, 440 is the application of the JGAA principles, and on 423 is the same set of figures under the IAS principles. And when you look at the bottom line of all 6 tables, there is only one table that comes out at 25%, and that is Mr. Christie's figure. And Mr. Sadler, in his affidavit, responding to Mr. Christie at page 227 to 228, shows why that position is untenable. And I would ask your lordships to look at starting at paragraph 11 on 227 and going straight through to 14 on 228. The main point being made as to why Mr. Christie's position is not tenable is that in paragraph 12 on page 227 over to the top of 228. And so in closing, my lords, I wanted to say that the major part of the focus here in relation to the interpretation of clause 2 has been in relation to the top part of the clause, not in relation to the bottom part of the clause. And the whole clause has to be looked at. And you don't get to the top part of the clause without first satisfying the prerequisite in the bottom part of the clause. So that regardless of whether consolidated profit before tax is a term of art or whether it is a line item, under the formula, profit share is not triggered unless that 25% threshold is reached. if the minority interest is not deducted, the profit to the shareholders would only be 24.4%. That is, it would not be in excess of 25% of shareholder funds from the previous year. And if it's not in excess of 25% of shareholder funds from the previous year, there is no trigger. You don't get to the top part of the clause.
What do you mean by the top part?
About
6%.
6%.
Right.
Because it's provided that such profit is in excess of 25% of shareholders' funds. So the first thing you have to do is make sure that's why the 25% of shareholders' funds. Now, the only person who said that 25% of shareholders' funds was reached was Mr. Christie. But Mr. Christie in doing his calculation was flying in the face of comparing like with like. He was not.
That undoubtedly is the case. I mean, we're well aware of that. I mean, the fact is, in order to reach a sensible accounting balance between the interests of the shareholders and the interests of the staff, then you ought to compare like with like. Right. The question, however, that we've been discussing today is whether at the time the contract was entered into, what the parties were referring to was a known line in the published accounts of the group, which both the company and the company and the staff could see and work with, or whether there needed to be something more sophisticated done. And the argument against you isn't that the result that the staff association is complaining achieves a proper balance. It is simply that that's the contract the bank entered into, and the staff is asserting, like it or not, that's what they wish to enforce.
Yes, my lord, but when you apply the formula, when you apply that formula to the material before in the financial statements, when you apply that formula to the material in the financial statements, you must come up with a figure that is more than 25% of shareholder funds.
If you just take the figure of consolidated profit, or take out the word consolidated profit before taxation, and ignore the fact that you later deduct minority interests, you do come up with a figure that is more than 25%.
But then if the profits that are attributable to the minority interests are never a part of shareholder funds. If you use that,
we have that point very clearly in our minds.
Very well, my lord.
I fully understand why the accountant, Mr. James, says that one should compare like with like. The question is, did this contract provide for that? Did it envisage there were subsidiaries, or would be in the future subsidiaries with minority interests?
Well, if comparing like,
the issue for us.
Yes, my lords, and if comparing like with like is the ordinary applicable thing to do, why would you not do it? Why would you not do it? Because that's the only way that you get to 25%, and if you don't get to 25%, that's the end of the case. I mean, there is no trigger to profit share, and then there is nothing else. Well,
whether or not they get to 25% depends on our interpretation of the phrase.
Yes, my lords. Yes, my lords. I fully understand that. So that I was just trying to say that the entire formula, top and bottom, looked at together, my lords.
Yes, I see that.
And that would be my reply, my lords.
Yes, thank you.
Unless I can have any further.
Thank you very much. Well, the board is very grateful to council for the submissions. We look forward to receiving the submissions that were put before Mr. Justice Sykes in relation to interest by the 19th of January. If you can make them available to us beforehand, so much the better. I would also like to thank those who have helped Council in preparing the papers for today's appeal. The Board will take time to consider what advice they humbly tender to His Majesty. Thank you.